Thank you, Mr Acting Deputy President. I'd like to rise to make a few remarks about the Intelligence and Security Committee's report into the Australian Citizenship Amendment, Allegiance to Australia Bill of 2015. The report goes into, obviously, the purpose of the bill, but also takes some detailed look at the sections of the bill, particularly proposed section 33AA, which is renunciation by conduct, proposed section 35, which is service outside of Australia in armed forces of an enemy country or a declared terrorist organisation, and proposed section 35A, conviction for terrorism offences and certain other offences. There are also some proposed amendments to section 36, which deal with the children of responsible parents who cease to be citizenship, and proposed section 36A, which highlights that there can be no resumption of citizenship if it ceases under any of the previous provisions. The report follows on from the fact that the Parliament has recognised that Australian citizenship is a common bond involving reciprocal rights and obligations, and that citizenship, the citizens may, through certain conduct which is incompatible with the shared values of Australian or Australian interests, or if they engage in acts that are intended to harm Australia's or Australians' interests, they have severed that bond and repudiated their allegiance to Australia. And so this is historical. We see going right back to just after World War II. There were provisions put in law whereby somebody who served in the armed forces of a foreign nation who were at war with Australia, by their conduct, have automatically lost their citizenship. And what we're proposing here is that there are explicit powers for the cessation of Australian citizenship for dual citizens, where they repudiate their allegiance to Australia by engaging in terrorism-related conduct or through convictions for such conduct. We had a number of recommendations to this bill, and the committee was seized of the fact that we have a balancing job to do, providing our agencies, the people, particularly in the AFP, who literally sometimes put their lives on the line, people within agencies such as ASIO and ACIS, who work hard to keep Australians safe. We need to give them the tools that they need to do their job, but at the same time, the very things that make us a liberal, as in small L liberal, plural, secular democracy, freedom of speech, freedom of association, we need to preserve those characteristics of our society. And so what the committee attempted to do during its consideration of this legislation was to make sure that these measures provided the outcome, or at least the majority of the outcome that the agencies were after, but at the same time protected those fundamental elements that we rightly say characterise the Australian society. So in the 6 minutes I've got, I don't have time to run through all the recommendations because there were quite a few, but I would just note that despite the fact that there was a deal of dialogue on the committee, that we have reached a bipartisan position, particularly with the cooperation and detailed briefings by the agencies. Members of the committees from both of the major parties reached an understanding and a position where we felt that we could bring before the Parliament recommendations to the government that will give us that balance that we need. Particularly for section 33AA, we have limited that to people who have engaged in relevant conduct offshore, or those who have engaged in relevant conduct onshore but left Australia before being charged and brought to trial in respect of that conduct. So the effect of that means that if you are onshore, your conduct alone is not going to lead to the automatic revocation, because the opportunity is there to bring you before a court, to be tried and, as determined by the court, either found innocent or guilty. If found guilty, then clearly the revocation by conviction may apply, but the revocation by conduct won't. But it does mean that those people who travel overseas, and we have seen a number on social media and through television reports and others, where their conduct very clearly shows that they have joined a terrorist organisation, that they have acted contrary to the interests of Australia and Australians, that conduct alone, if they are dual citizen, means that they will have revoked by their conduct their citizenship in Australia, which means they cannot come back. Likewise, for those who have engaged in conduct onshore but have fled before they can be apprehended, such that they are beyond the reasonable reach of our law enforcement agencies, then they can also lose their citizenship if they are dual nationals on the basis of that conduct. And so that was a protection that we felt was important, so that where possible people were brought before a judge as opposed to relying just on their conduct to actually lose their citizenship. We also note that the declared terrorist organisation is an important element in this. The Minister needs to declare organisations that, if you are a member of, join or support, activate some of these measures, and the recommendation is that this should be a disallowable instrument, which means that in addition to the briefs that are obviously given to the Minister, there is a broader group in the form of the Intelligence and Security Committee and ultimately the Parliament who have the opportunity to say, yes, that we concur, that group should be a declared organisation. And it's a safeguard, a protection, not that we realistically expect it in the current environment, but once something is law, who knows where that goes down the track. And so this is a way of providing that extra safeguard of both the committee, who can get the classified briefings, but also the broader Parliament, to have that disallowable instrument before them. We also looked at a number of the issues to do with retrospectivity. Now, retrospectivity is something that this Parliament does not look at lightly, but we have decided that in a limited case, where somebody has been convicted of a terrorism offence carrying a penalty of at least 10 years, and that has occurred within the last 10 years, then this legislation will apply to them. That conviction will be sufficient for them to lose their Australian citizenship if they are a dual citizen. And so it's an unusual step, but we again feel as though that provides a check and a balance. It is, by its very nature, the recommendation means it's for a limited time frame, so it doesn't extend into the future, and it captures only the most serious of offences where people have threatened Australians or Australians' interest by their actions. We have also looked particularly at the area of children. One of the unique characteristics of the threat that we are currently facing is that we see an increasing number of young people caught up in this. In some cases, the children of people who have engaged in terrorist activities, and clearly, and following from some of the precedents we have under the Criminal Code, children under 10 clearly are not going to be held accountable for their actions, nor necessarily should they lose their citizenship as a result of the conduct of the parent. However, again, taking the provisions that already exist that categorise children between 10 to 14 and then above up to 18, we have put in place some measures so that children under 14 years old cannot be subject to sections 33AA or 35, but capturing those children between 14 and 18 years is an important tool to allow to the authorities, because we are seeing so many in that age bracket, particularly at the older end, who are making very conscious, informed decisions about their actions. As I said, Mr Acting Deputy President, I don't have time to run through all the other recommendations here, but it is a good example for those listening to this debate of the Australian Parliament working well, constructively, in a bipartisan manner for the national interest.